Good afternoon, everyone, and welcome. I'm Leon Smith. I am the Executive Director here at Citizens for Juvenile Justice, and I want to thank you all for joining us today for the launch of our latest issue brief, Justice by Geography, Differential Treatment of Youth by Locality at Juvenile Legal System Decision Points. The treatment of our children and youth by systems designed to serve them should not vary based upon the color of their skin or by where they reside. But as you will learn today, that is unfortunately the reality that we have here in Massachusetts. In today's program, we will hear a presentation of the findings of our report and key questions. Then we will have time after the presentation for a question and answer session. Some key points to set the stage for this brief and for you to keep in mind as you take in the presentation. Despite Massachusetts having a unified juvenile court system, local and county system actors operate differently, and this has a real impact on young people. Racial inequities at juvenile legal system points are very real, and disparities at the front door of the system are compounded by local policing practices. And it's multiple system actors working together, either in a coordinated or uncoordinated way, that make these differences so challenging to address. Now, before we get started, I'm going to do some brief housekeeping items. We want to have people who aren't presenting muted to avoid any background noise. We're going to ask you to please hold your questions until the end of the presentation. However, as the presentation goes along, please feel free to put questions in the chat, and we will make sure to prioritize and get to them during the Q&A session. We've also invited members of the press today, so portions of this discussion may be quoted in the media. Lastly, the session is being recorded. I also want to give you a reminder, if you'd like to view the report as we are going along, you can download it at www.cfjj.org/justice-by-geography. So now that we've been able to set the stage, without further delay, I will turn it over to Josh Dankoff, our Director of Strategic Initiatives, and Sarah Shepley, our Data and Policy Fellow, who are going to present the report's findings. Thank you.
Thank you so much, Leon, and it's a pleasure to see everyone here. I'm going to share my screen in a second here, and we will get right into it. All right. What can you guys see?
We have a blank white screen, Josh.
That's not a good thing. Give me 1 second, folks. This is going to work. I'll just start with some introductory words. So first of all, this report, Justice by Geography, is a little different in a couple ways than some other past CfJJ reports. First of all, about a decade ago, CfJJ was putting together a series of reports called data points, where CfJJ was pulling together data based on public records request. And that is not as necessary because public-facing data has improved somewhat over the last several years around juvenile justice data in Massachusetts. This is in part because of the Juvenile Justice Policy and Data Board, and this is part because the trial court and the juvenile court and probation have public-facing Tableau dashboards that have data, and the trial court even has some data in the form of a data set that you can look at and download. But it's very important to know. So this sort of report, we are pulling from publicly available data. But it is still our role and our job at CfJJ to provide context for the data, to tell stories about it, and also to point out areas where we think there are places for change and continual system improvement. So our hope for today, for this report and for the presentation, is to really spur conversation and spur system actors and local advocates to review the data and make changes to policy and practice in favor of fairness for young people in the Commonwealth. Another reason this report is a little different from other reports is that after the findings, we have key questions. A lot of times CfJJ reports have recommendations, this report has a lot of questions to spur on further discussion. We suggest some things, but I'd say it's a little bit of a lighter touch than some of our other reports. Now, there are certainly recommendations that we believe are important, but we really wanted to make sure that the report is a conversation starter for the system actors here. And a couple of other quick notes, just because we highlight some outliers here, right? We're looking geographically across the system, and we'll be talking about different counties that really stand out as being different from and often worse than, or the data point to outcomes that are worse for kids in those counties at those decision points. But just because a county is, perhaps the county you work in is maybe not mentioned as being the outlier, we encourage you to really still take a look. Just because your county is maybe not mentioned, you should still engage with the ideas and the data therein. And as Leon suggested, we're going to point at specific decision points here, but often it is a compound effect and the impact of one system actor passing on, making decisions that pass children to the next decision point that have a cumulative effect, as we'll see. So with those things said, hello. All right, so our, as a quick overview, we're going to look at 4 major decision points tonight, and also talk about the youthful offender statute, and then offer some questions and answer. Those decision points are applications for complaint, talk about some of the factors that, some of the decisions that happen for youth in pretrial proceedings. We'll talk about adjudication and disposition. And just as a reminder, in this chart over on the right side, which we took inspiration from the JPAD in the report, the system is a bit of the juvenile justice system is a bit of a funnel, right? There are a lot of alleged delinquent offenses, and a smaller number of arrests, a smaller number of complaints, and so on down the line. And most cases do not make it to the very end of the system. Most cases will be diverted and find a sort of an off-ramp to the system. So just keep that in mind, that the numbers get smaller throughout. Before we dive into the major findings at those decision points, we want to just highlight one very important thing, which is that uneven policing practices are really driving both geographic and racial disparities here in Massachusetts. Black youth are more than 4 times more likely than white youth to experience a custodial arrest, and Latina youth are 3 times more likely to experience a custodial arrest than what you would expect based on the numbers in their population. So, in other words, police here are the gatekeeper at the front door of the juvenile justice system, and we've seen that police are not treating all youth the same, both between different municipalities and also within municipalities. We're concerned at many points that aggressive policing strategies that target hotspot policing practices, especially those employed in larger cities, are driving these disparities. And this is especially, we've seen, if you haven't looked at the report put out by JPAD at the end of last year, it's quoted here in the bottom right, the racial and ethnic disparities at the front door of the Massachusetts juvenile justice system. That report really spells out the important role that police play, because that's going to impact all of the remaining decision points. To make reference to a couple of pieces of research that CfJJ has done in the past, we've seen in the We Are the Prey report on New Bedford that there are disparate policing practices within cities, and also on the 2 Blue report. So on the right side, you see a map of Boston. On the left side, you see a map of New Bedford, just as examples. And arrests and field interrogation and observations, police contacts are not equally distributed around cities and around the Commonwealth. And they're definitely highlighted and more prevalent in areas where youth of color have a higher population density. And that is by design, by police practice. And we have, just to say that these are These are policies and practices that drive disparities throughout the rest of the system. We did not get to the level of, well, police practice also impact later on. And I just want to make reference to the Mass Inc. report now from 5 or 6 years ago called The Geography of Incarceration, that these police points, police contacts impact what's happening way later in the system as well, right? So that this report mapped out where people were coming out of jails and down to the address level. This is not data that's available on the juvenile system, but this is available from the adult system. And again, looking at that map of Boston, you can see it is not equally distributed as well. Sorry about that. All right, I'm now going to pass this over to my colleague, Sarah Shepley, who's going to talk about some of these first decision points.
Okay, so the first step into the juvenile court process is the application for complaint, which you can see designated by the arrows on the right. And so there are two methods for referring kids to court. The first is through a custodial arrest. So a police officer will arrest that youth and take them into custody, or they can issue a summons to appear in court. You can go on to the next slide. So at this decision point, police are the main decision makers here. And when they suspect a youth is engaging in delinquent behavior, they can do three things typically. They can dismiss that youth and issue a warning. They can refer that youth to community alternatives, which is also known as police level diversion, or they can decide to issue a formal application for complaint, again, through a physical arrest or through a summons. So this first finding is looking at all applications for complaint, so both the arrests and the summons coming into Massachusetts juvenile courts. And this chart here is looking at per capita rates. So that's looking at the numbers of applications in relation to each county's population. So looking at this chart, the blue bar represents the state rate, so the statewide rate. And you can see that's about 18 applications for complaint per 1,000 youth. And then at the top, Barnstable is a very apparent outlier here with nearly 50 applications for complaint per 1,000 youth. So this rate is really high and it's very concerning because it's even 2 times greater than the state rate. So we have identified Barnstable as an outlier, but it's also really important to notice that Essex County is second here with a rate that's about 1.3 times higher than the state average. And Essex has a much larger population than Barnstable. So looking at this chart, our takeaway here is that these numbers alone don't tell us about differential offending and differential policing, but it also does not necessarily mean that there are higher levels or higher severity of crime in the counties with higher rates. So these rates can provide insight into policing and court practices that may be resulting in kids being brought into the juvenile legal system at differential rates. So you can go on to the next slide. So our first key question here is, what is driving Barnstable and Essex's rate of applications for complaint? So based on some 29 research, Barnstable County system actors did report barriers to accessing community alternatives and some gaps in those offerings. But really, these rates can point to policing practices and especially what behaviors police in these counties are determining require court involvement rather than diversion or dismissal. And we have heard that in Essex County, which is again identified as an outlier here, the bar is lower for behaviors that police are determining require formal court involvement. So this next finding focuses on applications for complaint that are arrest-based. And again, police have 2 options when they're thinking about a formal application for complaint. They can either physically arrest the youth or issue a summons. And a summons is the preferred method for bringing a youth to court. So looking at rates of arrest, about 43% of all applications for complaint in the Commonwealth are arrest-based. But meanwhile, in Hampden, about 69% of all applications are arrest-based. And Suffolk also had a high rate of 66% of applications for complaint being arrest-based. And especially looking at the offense types, which is also displayed here at the top graph, 91%, so nearly all of school disturbance and public order complaints that are occurring in Hampden are initiated via arrest. And this is really concerning because these types of offenses are typically considered less severe. And just looking at these numbers, this is the school to prison pipeline in data form. So just looking at these rates, the takeaway here is that police in these counties are over arresting and arresting for offenses that would otherwise not result in arrest in other counties. And so just thinking about these arrest rates, we want to know, are these more indicative of policing practices or the types of behavior that youth are engaging in? And we think a next step for future research that would be valuable is a closer look at specific police departments within these counties to see which specific municipalities are driving these high rates. And we think this would be important as a next step to hold these departments accountable for the discretion around what requires court involvement. And then this last finding under applications for complaint is talking about the summons-based complaints, so non-arrest. And the main decision maker here is the clerk magistrate. And this, their job is to review the applications for complaint that are coming to court as non-arrest summons. And if they find probable cause, the case continues to court, or they can divert the case. And diversion at this stage is very important because this is before youth have a formal delinquency case issued. So the graph below displays all summons. So these are non-arrest based complaints. So all the complaints that are coming in as summons. And you can see the county by county breakdown. The bars on the left are summons that are diverted or designated complaint not to issue. And the bars on the right in the darker color are the summons that are issued as formal delinquency complaints. And so here we have Essex and Hampden as our outliers at this decision point. So the Commonwealth average, which isn't displayed on this chart, is about 36% of summons being issued as delinquency complaints. Meanwhile, in Essex, 65% of these summons are being issued as delinquency complaints. And while Hampden's rate is not as high as Essex, it's still important to identify that as an outlier with a relatively high rate of summons being issued as delinquency complaints. And you can go to the next slide. Okay, so our key question says, why are Essex County clerk magistrates issuing these delinquency complaints at higher rates in other counties when they could be dismissing or diverting? And so from the first graph we looked at under applications for complaint, we could see that Essex County does have a large number of applications for complaint entering its juvenile court. And now we can see that there are also a large number of these being issued as delinquency complaints. So thinking about Essex, we see this as a combination of system actors from the police to the clerk magistrate to the DA, which are resulting in Essex being a repeated and compounding outlier. And so we really believe that there needs to be some kind of course correction among these system actors at the early stages of the juvenile legal system. Okay, so you can go on to the next slide. So that's all for applications for complaint. And the next decision point are pretrial proceedings, and we'll be presenting findings on dangerousness hearings and pretrial detention. And Josh will say a few words before I continue on to the rest of the findings.
Thanks, Sarah. As Sarah mentioned, we will be talking about pretrial detention, which is a decision that a juvenile court judge makes whether to hold a youth in DYS custody prior to trial. And I just want to note at this point that in general, we know that pretrial detention is not good for young people, that it's traumatic and linked to negative outcomes. And in fact, the entire apparatus, the Juvenile Detention Alternatives Initiatives, JDAI, which is quite active in Massachusetts, has been using that as a basis to help try to work with actors to reduce the reliance on detention. A quick also note on dangerousness hearings, which are sometimes called 58A hearings. These are hearings that are requested by a district attorney, and they look at the nature of the offense and whether young youth's release poses a danger to the safety of another person or the community. And with recent Supreme Judicial Court jurisprudence, the Brannigan case, which reduced the sort of use of bail and pretrial detention, we've seen a large increase in the use of dangerousness hearings across the state, but not equally. So just want to point out those things to lead into our findings for what we see in Massachusetts. Back to you, Sarah. Thank you.
Yes, so this first finding is focusing on dangerousness hearings, which Josh just explained about. And so the main decision maker here is the district attorney. And we have two ways of looking at dangerousness hearings. We have on the left a per capita rate graph or chart, and then on the right we have a proportion chart. So I'll talk about the per capita rate chart first. As a reminder, per capita rate is looking at these numbers in relation to each county's population. So looking at this chart right here, you can see the Massachusetts rate is about 4 dangerousness hearings per 100,000 youth, but Bristol and Essex really stand out here with super high rates that are even higher than the next highest rates in Worcester, Berkshire, and Suffolk. So we're really concerned with these numbers because they reflect what we believe to be an overuse, over requesting by district attorneys. Then this graph on the right is looking at the percent of arraigned youth who are assigned dangerousness hearings by county. And here Berkshire is a clear outlier with 20% of its arraigned youth being assigned dangerousness hearings, and that is about 2 times higher than the Massachusetts rate. And even comparing within geographic similarities, Berkshire's rate is about 20 times higher than nearby Franklin and Hampshire counties. And we also wanted to note that we did look at the numbers of dangerousness hearings in the adult courts. So looking at the adult district and superior courts, and Essex is a huge outlier with per capita rates over twice that of the Commonwealth in the adult courts as well. And Berkshire and Bristol had the highest rates after Essex, and Hampden stands out as well. So we also found some really concerning racial and ethnic disparities in dangerousness hearings. As you can see, in nearly every county, over 50% of dangerousness hearings were assigned for Black and Latina youth. And it's really important to keep in mind that just 28% of the Massachusetts youth population are Black and Latina. And this is not included in this slide, but it's elaborated more on in the report. But the distribution of offense types did not vary greatly between counties, and most of these offenses were for weapons offenses or offenses against a person. And thinking about weapons offenses, we know that there are differential rates in gun carriage between youth of color and white youth for community and cultural context. For example, a 2020 report, which is linked below from the Center for Court Innovation, found that 9 out of 10 youth who carry weapons in New York City carry out of self-protection. And this is self-protection from community violence as well as from fear of police violence. So we're really concerned by these high rates of youth of color among dangerousness hearings because we really believe that they reflect trends in over-policing and higher rates of arrests for Black and Latina youth who are found and charged with simple gun possession. And you can't just arrest your way out of the problem of gun violence, nor does using pretrial detention solve that issue. Another reason why we believe these rates reflect an overuse of dangerous hearings in Berkshire, Essex, and Bristol are because DAs in these counties are moving for dangerousness hearings for misdemeanor offenses as well. And so this is a real chance for future research that we were not able to do in the scope of this report. And so we think a valuable aspect to examine is are similarly situated white youth being subjected to dangerousness hearings at a lower rate than youth of color. Our next finding focuses on pretrial detention, and to reiterate, pretrial detention is a very traumatic outcome for youth who are court involved, and it leads to negative outcomes later in the system process as well. Thinking about our decision makers at this point, judges have the legal authority to place a youth in pretrial detention, but earlier decision makers such as the police and the district attorney do have a role here in influencing those decisions. So our chart on the left looks at the percent of arraigned cases that are assigned pretrial detention by county. And Suffolk has over half of their arraigned youth being put into pretrial detention. So this is a clear outlier here that is displaying some concerning rates of pretrial detention. And our graph on the right is a statewide graph. So this is all youth in the Commonwealth who are in pretrial detention, broken down by race and ethnicity. And so you can see most youth in pretrial detention in the state of Massachusetts are Black and Latina youth. And again, keep in mind that just 28% of the Massachusetts youth population are Black and Latina. You can move on to the next slide. So our key question here is looking at Suffolk's high pretrial detention rate. We want to focus on the prosecutorial and judicial discretion that is being used for these arraigned cases. So we encourage an examination of district attorney recommendations and the judicial decisions around these recommendations that are being made in Suffolk. So I will pass the rest on to Josh.
Thanks so much, Sarah. Moving along, we've covered applications for complaint and some of the pretrial decision-making processes. We're now going to look at adjudication. That's the language in the juvenile court around for a finding of youth being delinquent or non-delinquent, or a case can be continued without a finding. So at the point of adjudication, we find that Suffolk County has the highest rate of all the cases that are adjudicated delinquent. Of all the cases that are end in an adjudication and aren't diverted earlier, Suffolk County has the highest rate of delinquent adjudications among Massachusetts, while Essex has the lowest. And I really want to focus here on Essex and these counties that have a really relatively low rate of adjudication of delinquent. What this basically means is that cases, as we've seen in Essex in the previous findings, a lot of cases are moving forward, and it's only at this point where it seems like there's a course correction, and most of the cases are not ending in adjudication of delinquency. So it seems that while in some counties we see that the state average is about 35%, in Essex only 21% of the cases are ending in an adjudication of delinquency. So the juvenile court judges in Essex are in some ways course correcting for earlier system actors who missed diversion opportunities and are ushering too many cases forward. But for us, this is concerning because it shouldn't come, the cases, a lot of cases should not even come this far. For a case to come all the way to the point of adjudication, that means that a youth has been possibly arrested, had a lengthy court, had to go back to court many times, possibly been detained pre-trial, and had a case hanging over their heads for a long time, only to have the case not in an adjudication of delinquency. So we're concerned about Essex as well as some of these other counties that are on the lower end, especially. These data here do not show or analyze the wide practice in Massachusetts of a quaff, a continuation without a finding in juvenile court, nor do the data show juvenile court cases that may have been dropped with a youthful offender case was opened, which, as we saw, also occurs a lot in Essex County. But just to say, the takeaway here is that this course correction at the level of adjudication in Essex and Middlesex and Barnstable is concerning, but these reflect what is happening earlier for system actors as well. So our key question here is, what do delinquent adjudication rates reveal about diversion practices in Suffolk and Essex? And an area for future research could be an examination of diversion standards, as well as prosecutorial and judicial attitudes towards diversion, particularly in light of the new diversion programming that is being piloted in 5 counties under the support of the Office of the Child Advocate and Department of Youth Services. All right, we are now towards the end of the court process in disposition. If a youth is adjudicated delinquent, a juvenile court judge can decide what's going to happen to that young person. Are they going to be committed to the Department of Youth Services, or are they going to receive probation, or is there going to be nothing else happening? So there's an important decision point. And again, the numbers are not very large. The juvenile justice, the system size has decreased here in Massachusetts over the last 10 to 15 years quite significantly. But there are still cases that do reach this stage. And so our finding is that for more than half of the youth that are adjudicated delinquent in Hampden County get committed to the Department of Youth Services. That's the highest there. While in contrast, youth in Barnstable County is another outlier that receive risk need probation at higher rates than other counties. So the decision maker here is the judge. And in Hampden, we see that 61% of the youth who are adjudicated delinquent are committed to the Department of Youth Services. And that right after that are Suffolk at 53% and Berkshire at 50%. By contrast, Barnstable, most of the young people, 75%, end up in probation. And just to note, in a couple of counties, Bristol County, 40% of youth who are adjudicated delinquent have no sanction whatsoever. So it's sort of the equivalent maybe of time served, though we don't know the exact stories behind all of those cases. But that is possibly concerning that a case gets so far along and then finally they're adjudicated delinquent, but with no sanction added. It leads you sort of to wonder, why is that case getting this far along in the system at all? So a key question here is, what do these differences in adjudication rates tell us about differential policing, as well as differential treatment by juvenile legal system actors throughout the system? Okay. So the final piece of this report is a little bit of a snapshot of the youthful offender statute and data around youthful offenders. And just as a reminder, the youthful offender statute from the 1990s created this sort of in-between phase, these cases that still take place in juvenile court, in front of juvenile court judges, but the judges can either, in their sentencing, can either give a juvenile court sentence, a DYS sentence, or they can give an adult sentence, or a combination of the both. And the criteria are listed here for which young people could be tried as a youthful offender. Our finding here is that youthful offender cases are brought forward most in just a few counties. So this is data from fiscal year 2022, and we see that Essex County, the blue lines are the raw numbers, that Essex and Suffolk and Bristol make up the largest numbers of youthful offender filings per capita, and then or the largest raw numbers. And then in green, you have the per capita numbers, right? So in Suffolk, the numbers are more than 11.3 youthful offender cases brought per 10,000, and in Essex, 6.6. So we are concerned here that some of these rates are higher than what you would expect to see based on population. So that's the case for Essex, that has the 3rd highest population in the Commonwealth, the 2nd highest number of youthful offender case filings. And also that while most counties are staying flat in their numbers over the last several years or going down, Suffolk County is the only county to have seen an increase in the number of youthful offender indictments than between fiscal year 21 and 22. There are also very concerning racial disparities in youthful offender indictments, that in Middlesex, Plymouth, and Suffolk counties, either 77 or 78% of all of the YO charges were Black youth. And in Essex County, 53% of all YO charges were Latina youth. A key question here is whether the youthful offender statute is in practice achieving developmentally appropriate outcomes for the children subject to the adult sentences allowed under the statute. We are working at CfJJ on another issue brief specifically on the youthful the data from youthful offenders, and I'll just say it's forthcoming. We're working on that now, but wanted to make sure that this was we had some data here. There's really an opportunity we see in the youthful offender area for DA policy and practice changes around YO charging. And especially given that there are 3 new district attorneys elected in 2022, there's really an opportunity to look at that, including some of the counties there that we mentioned with new higher numbers, including Suffolk and Essex. In his next step, we suggest some research into the youthful offender indictments and sanctions that really look at DA patterns and judicial sentencing patterns, and that look at DA decisions to use or forego a YO indictment when faced with equally chargeable cases between white youth and youth of color. Again, this is not research that we were able to do based on available data, but we do recommend this research moving forward. That concludes our findings for the Justice by Geography report. Just a reminder that CfJJ as an organization has many different wings to our work, including some legislative advocacy and research and writing in support of that. Please consider following us on Twitter and Facebook. Sign up to our JJ News. And if you have any questions about this work, please feel free to reach out and happy to talk about it. We're going to switch over to question and answer. Yes, back to you, Leon.
No, Josh, Sarah, thank you so much. Very, very informative, a lot of information. So now we're going to be transitioning to our question and answer session. If you have a question, you have 2 options. One, you can simply use the raise hand feature and Josh will call upon you, or feel free to put a question in the chat and we'll make sure that it gets asked as well. If you are joining by phone, you can mute and unmute yourself by pressing *6 and then raise your hand by pressing *9. And in looking at the chat, Josh, I will get us started, Josh and Sarah. The first question that came in was around the scope of the definition of adjudication that you all used in doing this research, and whether that includes pleas of delinquency as well as findings by a judge at trial. So let's kick off there and then we'll be getting questions as they come in.
Great. My understanding from the data is that if a plea to a guilty plea would lead to an adjudication of delinquency, and so that would be included. Again, the data that we're looking at is from, I don't remember that specific data point for the adjudications, but I would either from the JPAD that pulled data from the courts or from the trial court themselves on their public-facing dashboards.
Yeah, I was just going to add in that was from the Massachusetts Juvenile Court Tableau data board. So we used the adjudications and the numbers that they had on there.
The second question for Josh and Sarah from the chat. Do you have any data on how many kids were excluded from school during this process, meaning during the court process?
Thanks for that question. The short answer is not in this report. We do not have, and most of the time for the public-facing data that is available from the Office of the Child Advocate or the courts is their linked education data. That said, you can assume, that said, we know a lot about the school to prison pipeline, and that school exclusion, both in terms of detention and expulsion from school as a precursor to juvenile court involvement, as well as arrests that take place in school that can bring kids into the juvenile court, are of very large concern to us. And I'd say again, one of the reasons why DYS, that pretrial detention is harmful, is that it is most of the time pulling a young person out of their community and out of their home school. While they are going to attend school at DYS, it's a different situation. It's a disruption, and it is sometimes challenging for them to return to their home school. Sometimes made even more challenging by school districts that don't want them back. So no, the data aren't there, and thank you for pointing that out. That would be a lovely thing to include. And we are working also on a couple of reports here, looking at specific municipalities on school exclusion. Leon, do you want to add anything there?
Two quick points to add before getting to the next question. One, if you're interested in rates of school exclusion in any of these counties, you can go to the Department of Elementary and Secondary Education website, where they do have data on school exclusion as well. Additionally, CfJJ at our school to prison pipeline site, we have data on exclusion rates by race, disability, and economic disadvantage in certain gateway cities. So while not in this report, that data is available. But I also want to illuminate on one of the points Josh made in the presentation, where these cases, kids are arrested, they're brought into the system, and these cases go all the way to the point of disposition, and then they don't go forward. During that court process, young people are going back and forth to court during the process. Each time they do, that's a day missed out of school, that's a day a parent misses out of work, only to have that case resolved in the end. So when young people hit the court system, merely participating in the court process does also lead to missed time in the classroom as well. But I just want to sum those two up. But Meredith Moody, you've been very patient and you've had your hand up. I want to go to your question next.
Hi, thanks. Going back to the application for complaint section about Essex County, I wasn't really clear about what the clerk magistrate's role was, but I did hear loud and clear that the clerk magistrate had declined to work on the pilot program that started last year for diversion. So if you could elaborate a little bit on that, that would be a big help.
Absolutely. So for cases after an arrest or summons, a case will go to a clerk magistrate before a young person is arraigned, and a clerk will do what's called a probable cause hearing to determine whether there's enough evidence to even move forward and bring the case to the DA. And different clerks are elected positions and differ quite widely across the state in the practice here. So we see some clerk magistrates really take this as an opportunity to get cases out of the juvenile court that probably should not be there based on the facts before them, and others see their role a little more as a rubber stamp. Let's just say that they are assuming that that what the police say should go, and that is enough to bring the case forward.
Thank you so much for your question, Meredith. We have some additional questions coming through the chat. One, Josh and Sarah, involves a quaff or continuance without a finding. As this is common in Massachusetts, are there any special consequences of a quaff for young people?
A quaff can mean so many different things depending on what county you're in and what case, what the case means. And it can basically it's sort of this in between, and in some counties it's most of the cases that come before a judge and in a quaff. If there's a sort of diversion or trying to get a kid's services, or if the kid is doing better, and the DA doesn't want to try the case or doesn't want to agree to drop the case, then it's sort of putting it on the judge to issue this continuing the case, but with no finding. So the short answer is it can mean all sorts of things across the state. We did not really look in detail. That would be a great other research project to pull actual case files. You need permission to do that, to really do a survey of what does a quaff mean, because when you look at the data, it's a little hard to tell. But thank you for the question.
Great answer. So a quaff does not result in an immediate finding of delinquency because it is continued without that finding, but a young person, while that case is continued, is still under the supervision of probation. And if they are not able to abide by terms and conditions, they can still be violated. So while a quaff is considered preferable to a finding of delinquency and being placed on probation, a young person still has a number of things that they have to do in the eyes of the court, and they still can face a violation there.
And just to note, there's a note that was added in the chat. I'm guessing from someone who works in defense as a public defender, that they have young people, clients, kids who are excluded from school throughout the whole term of the quaff until the dismissal happens. So it might be a continuation for 6 months. That during that whole time, a kid can be excluded from school, which is a problem.
Absolutely. Great comment. Another great question in the chat. Great question in the chat that I want to give to Josh and Sarah. Is there a sense of those counties where the numbers are not outliers, what is working and what is successful? And do you all have an idea of best practices that are working in those counties that don't have some of those bad outcomes?
That is an enlightening question. So I'd say one of the challenges here is that while there is a unified juvenile court in Massachusetts, right, that there's a statewide system of probation and a statewide system of the juvenile court, and a statewide DYS, that there are these differences in practice in different counties. And it's not, I don't know, I don't actually, from this research, I don't think that I'm ready to lift up anything as best practices, but there are certainly examples in the area of diversion for the counties that have taken on either have robust diversion programs at the level of police, the level of DA. I'd say it's inconsistent for rolling out of the judicial diversion from the 2018 legislation. And I'm cautiously optimistic about the diversion pilot projects that we mentioned before that we're in 3 and are just expanding to 5. But I think any change like that, introducing this new type way of doing diversion is change, and the status quo is easier, and change is hard for professionals to think through and enact, even if that's in the best interest of young people.
Thank you so much. Are there any other questions? I'm looking to chat. I believe we have reached most that have been left in the chat. But I want to give anyone an opportunity while we have Josh and Sarah here to ask any other questions you have about the research, while also reminding you all again, please go to CfJJ.org and consider downloading a copy of the report, as well as sharing this report within your networks.
Yeah, and I'll just end by saying thanks for coming, and we would be happy to talk about this. You know, a lot of these decisions and practice questions really happen at the county level. And we'd be happy if you are a practitioner in the system working, you know, be happy to look at this data with you on what does that look like in your county, and think about what are some of the areas of change and ways that, you know, you can be agents of change to use this, to bring this to those system actors to really move towards the better practices that we look for in favor of developmentally appropriate responses to youth actions.
Absolutely.
And
So
there's
again,
a question on the recording. This will be up on our website on that same Justice by Geography, the same place where the report is now. I'll drop that one more time in the chat. Give us a couple days to get it up there, but we will put the recording up there.
yes. And also, we'd just like to state again on our social media at CfJJ on Twitter and Instagram, Citizens for Juvenile Justice, on LinkedIn and Facebook, and also look up Citizens for Juvenile Justice on our YouTube. We will be uploading this recording onto our YouTube channel as well. But with that, we want to thank you all for, right in before the buzzer. Candace, please go right ahead.
All right, I have my microphone up. I'm sorry. Okay, so you mentioned reviewing these by county. I'm wondering if that would be something to do at the JDAI level by county to kind of look at this data and come up with some next steps. Just throwing that idea out there, that's all. But
Yeah,
thank you for this.
absolutely. Yeah, and I've been in touch with the folks who staff JDI, and we're certainly interested in that. I think right now there's some staffing issues over there that have meant that some of the county committees are a little quieter than normal. But yes, this is, I'd say this is framed in a way to spur conversation, and would love to have this conversation at county level JDI. So
absolutely. Awesome. Thank you.
One other question, well, it's more of a statement and a question. Significant emotional disturbance and or autism spectrum in these numbers. Again, if you go to CfJJ, our school to prison pipeline site, and you look at our Gateway Cities report, you will see significant racial and ethnic disparities for students with disabilities in some of these counties. And Josh, please jump in. While this wasn't an area we looked at for this report, it would be an interesting question to look at that intersection of students with disabilities who are not only being excluded, but also who are finding themselves in the deep end of the juvenile justice system as well. But I'll pass that to you.
No, I don't have anything to add on this. We were not specifically looking at that. You know, there's maybe just as a closing this time. I've mentioned that this report was possible to analyze because of the improved data availability. And there's so much more in terms of really being able to follow the path of individual youth, de-identified, of course, but to understand how youth actually move from one point in the system to the next. And that there should certainly include starting in the community at schools, and starting and understanding which youth have had past or current DCF involvement and trauma histories. And I would add to that, you know, understanding whether there are diagnoses that are driving behavior, and whether the juvenile justice system is the appropriate or often not appropriate response to that behavior, either as an expression of trauma or as an expression of a diagnosis. So the data can be better, and also our practice can be better. And, you know, we're offering this as a conversation starter, and hopefully action starter as well. So thank you so much for your time, and we'll sign off from here.
Thank you all for coming.